Namaste one and all. My name is Dr. Aruna. I'm a faculty of law at CMR University School of Legal Studies. And today I'm going to give you a small overview about the Sexual Harassment of Women at Workplace Act. I'm going to tell it to you in a nutshell. And I'll just walk you through the various aspects of what this law already covers and what are all the reliefs which are available to people across the board. I'll tell you the nuances of the law, and I will also probably walk you through a couple of instances as to how to identify sexual harassment at workplace. One of the primary questions probably everyone has is, why should you even be talking about this? Because this is now a big problem which the country is facing. A lot of women in India are facing sexual harassment at workplace. So is this a problem only in India? No, it is not. It has been a worldwide problem. And in fact, there have been worldwide measures taken to address this particular issue. So if you go back into the history as to when this would have started, you will be startled to know that right from the time of Mahabharata, that is, Draupadi was also subject to sexual harassment at workplace by her employer. However, we don't have any remedial measures or anything which talks about how the law has taken course with regard to this particular problem. But then in the 1970s, what happened was in the Yale University, this became an issue. And there was a study which was conducted and they coined this term called sexual harassment. Till then, this was not a very popular term. So once this was done and people started sensitizing, they also understood in the study that quite a few women are suffering this and not venting it out. That is, they're not speaking about it at all. As far as India is concerned, one of the first instances where the Honorable Supreme Court spoke about sexual harassment is in the landmark case of Vishakha versus State of Rajasthan. Now, the court observed that, yes, workplace harassment is happening and there needs to be a mechanism to address this. So the court went ahead and gave guidelines, what we popularly know as the Vishakha Guidelines. And these were made into a set of guidelines which was to be followed by most employers from the year 1997. Now, the other person that you see on screen, you might not know him, but you know the movement which is against him, which is the #MeToo movement. Now, his name is Harley Winston. He was the Hollywood mogul who sexually harassed his peers. And one of the ladies who would not take it anymore went ahead and complained. So once she came up with this complaint, a lot of others also joined and they said, yes, even we have been harassed sexually at our workplaces. And you know how this movement has taken the momentum, and you know how many women have come out and they have broken the barriers and they have started speaking about sexual harassment at workplace. So after the 1997 Supreme Court case, in the year 2013, the legislature passed an act called as the Sexual Harassment of Women at Workplace Act, Prevention, Prohibition and Redressal. So this was done in the year 2013. So when this act came into force, this was viewed as a very good shield for women. They could go ahead and complain about being sexually abused at their workplace, and they could also look for remedy. So let us now understand what exactly is this sexual harassment. Section 2N of the Act speaks about sexual harassment. So what you see in front of you right now is the definition of sexual harassment at workplace. Now I have highlighted one word called as unwelcome. Now this is something that probably you need to remember. So when we say it is an unwelcome act, that means it is something which you do not want to take. Ideally, again, when we say sexual harassment, you obviously think it is physical harassment. So you think that there should be some form of an advance which is sexual in nature and which has to have like a touch or something like that. But this act has gone beyond that. It includes a lot, including, of course, the physical contact. It can be sexual favors which are asked for, sexually colored remarks, making any kind of a comment on a woman which is tainted sexually, you showing pornography, anything at all. Okay, so it can be verbal, non-verbal, anything which the woman does not feel comfortable about. So when I say unwelcome, it is the unwelcomeness of the woman. So the woman feels insecure. She feels sexually abused by such comments, looks, gestures, messages, whatever it is. So if the woman feels that it is not acceptable, and if she feels that it is a sexually colored remark and she does not want to take it, she can approach the relevant authority. Who the relevant authority is, I'll just tell you after I walk you through Section 3 of the Act. Now, Section 3 of the Act speaks about what sexual harassment is and how to prevent it. Now, if you look here, it says no woman shall be subject to sexual harassment at any workplace. Now, why this no woman? Because obviously the Act protects women. Ideal case scenario, it should have said employee, because we're talking about a workplace. But this is where the beauty of the Act lies. Here, the person who has suffered, that is a victim, is referred to as the aggrieved woman. So any person who is harassed sexually at a workplace is this aggrieved woman, which means that she need not be employed. She need not be an employee of that particular organization, which also means that the harasser, he can belong to some workplace, and it could be as part of his workplace that this sexual harassment is happening. So you have now understood what is sexual harassment. We've also said why it can be. Said the person who is the victim need not be the person who is the employee. Now, coming to the next thing that we need to understand is workplace. So what is a workplace? We all understand what is workplace, as in the place that you work in, the college, the university, the office, hospital, whatever you are working. Now here, the Act has been very, very specific in terms of making it very broad. So when it has defined workplace, it has not only confined itself to the four walls of this so-called institution where we work, it has taken it beyond that. So if you have to travel on work, and if that is where you have been harassed, you can approach the authority. If it is something connected, like you go to a client's place, which is part of your work, there again, if you are harassed, you can complain. So workplace has been given a very, very broad construction. Another beautiful aspect of this Act is the workplace is not only for those who are formally employed, it also includes people who are domestic help. So this workplace includes the houses of people where we engage domestic help. So if at the workplace of this domestic worker, if he or she has been or has subjected somebody to harassment, so this aggrieved woman who has suffered this sexual harassment can approach the appropriate authorities. Now, what kind of harassment can it be? The two forms that we generally classify here under this Act is one, what we call as the preferential treatment. That is what is also called as a quid pro quo, which means something in return for something. You want a promotion, you do this for me. You want the off for tomorrow, you do this for me. So doing this, whatever the person is asking for, has to be a sexual favor, which this person, whoever is aggrieved, is not willing to do. Similarly, when you're talking about detrimental treatment, we are talking about creating a hostile work condition. So if a person makes sexual advances, and if you have resisted the sexual advances, and you are clear that you do not want to budge to it, then subsequently your work can become hostile. That is, your workplace can become hostile. They can treat you very differently at the workplace. So in case of any of these, again, you can go ahead and make a complaint. The moment you are not happy, like I said earlier, if it is an unwelcome act at the workplace, either your workplace or the workplace of the harasser, and if it is anything which is not going to be something which is going to work out, in case like a quid pro quo or a hostile work condition, we already said that, yes, you can approach the appropriate authorities. Now, going on to who these appropriate authorities are. When we're talking about this appropriate authority, what the Act says is, if any organization employs 10 or more people, in that case, you have to have one internal committee. So this internal committee is the one which should hear the matter. So this aggrieved woman, the one that is who has suffered this sexual harassment, she will approach this internal committee. And once she approaches the internal committee, the committee has to take necessary actions. So at the institution level, it is called as the Internal Complaints Committee. And at the district level, it is called as the Local Complaints Committee or the Local Committee. Now, the formation of this committee is also very interesting. So since this is a woman-based issue, women are best at understanding these issues. So what happens is, in this instance, the internal committee has one person called as the presiding officer. Now, this presiding officer has to be a senior woman, and she has to be an employee of that particular organization. So when we say she's an employee of that particular organization, she is senior and she should be able to take actions. That is the whole point in having a senior woman as a member. So if an organization, if an institution has multiple branches, it is advisable that they have the internal committee in all their branches. But if it is not workable, then it should be set up at one place, and it should be published to the officials and all the employees as well as to where and who are the members of this particular committee. So other than this presiding officer, you also need to have two other members who are again employees who will be part of this committee. Over and above these people, there will be one external member. Now, this external member can belong to an NGO or any organization which works towards or which has sensitization towards the problems which women at workplace face. So on the whole, when you're looking at the committee members are generally supposed to know or should have functioned in some manner in addressing the issues with regard to women that is more desirable. And it is also required that more than half of these committee members should be women, and they are the ones who will look into these issues. So this is at the organization level. Next one is at the local level, that is the district level. So every district officer is supposed to identify and is supposed to constitute a local committee. So if you remember, I said earlier that even a domestic worker at home can also approach. So where will that person approach? That person can approach the local committee. Now, if the organization does not have more than 10 employees, then an internal committee is not required. So they can also approach this local committee for redressal. Other than that, the law, of course, requires the internal committee to be constituted. But if the employer has not constituted the internal committee, then again, this aggrieved woman can approach the local committee. Now, if you're an educational institution, there is a UGC regulations as well, which is the 2015 regulation with regard to addressing sexual harassment within the higher educational institutions. If a woman is not very happy approaching the internal committee, she also has an option. Again, this is a beautiful initiative taken by the Ministry for Women and Child Welfare. There is something called as a She Box. So this is an online forum where the aggrieved woman can file a complaint, and this complaint will be taken up by the appropriate authorities. This will be forwarded to them and they will address this particular complaint. It's a very simple process. You just have to log into the website. You can access the details on the website itself. You will see whether you want to register a complaint. And once you register the complaint, it is a 2 or 3 window process. You have to just fill in the details over there. And after it has been filed, you can also look at the status of this particular complaint. The Act also provides that you can approach the police, and if the woman, that is the aggrieved person, wants to approach the police, the internal committee can also assist them to approach the police. Now, the next question is, how should this complaint be addressed? So the procedure which is laid down is that once the aggrieved woman decides to make a complaint. Now, why I say decides to make a complaint is a lot of us are, we tend to ignore the sexual innuendos which are thrown at us, maybe for various reasons. But then once you have made up your mind, now again, the question is, so how many times should I have been harassed for me to go and file a complaint? At any instance, the moment you feel it is unwelcome, the moment you have decided that you do not want to take it anymore, approach the internal committee. This committee requires a written complaint, so you have to give it in writing, and the committee will then take it up for inquiry, and a notice will be sent to the other person. But what you need to keep in mind is that there is a 90-day window. So between the incident and filing of the complaint, it should not be more than 90 days. So once the complaint has been received by the committee, they will issue the copy of a complaint to the respondent, that is to the harasser. He has about 10 days to respond to this, and then the inquiry starts. Once this starts, and if the woman feels that this can be settled without too much of inquiry, in that case, conciliation can be started. So the matter can be settled. But what should be kept in mind here is that this conciliation should not be for compensation. It should not amount to some kind of a pecuniary benefit that the aggrieved person is getting. So if the conciliation doesn't go through, then the inquiry starts. And each and every person who is part of this shall be asked questions, and these will be recorded, and these will be maintained for document purposes. And once the committee finishes its inquiry, it can either find the respondent, that is the harasser, guilty or not guilty. So if the person is found guilty, then whatever is the recommendations, they will say what has to be done, and they can appropriately suggest what should be the action that can be taken against the person. If it is not very grievous, it could be as simple as giving a reprimand. But if it is something which is a lot more graver, then if there are service rules with regard to that, then accordingly that can be given, or whatever the internal committee feels appropriate, that kind of action can be taken. So they will record this in the report. And once this is done, then the management has to adhere to this report. Within 60 days, they have to go ahead and ensure that whatever is the recommendation of this committee, that has been enforced. Now, not all complaints are actual complaints. There can be certain instances where there are false complaints as well. And the Act has addressed that as well. So after the inquiry is done, if the committee comes to the conclusion that there is not much material, or if there is a false complaint made against the other person having certain ill feelings between them, in that case, they can go ahead and take action against the complainant as well. So the employer has been given certain sets of liabilities. One is to take action, whatever the internal committee says, they have to take action based on that, whether it is an actual complaint which has to be resolved, or whether you are looking at a false complaint where the person has to be punished. Both of them are taken accordingly. Now, each and every person who's involved in this inquiry has to maintain confidentiality. They cannot spill out any information with regard to who were the people who were involved, or what happened, what was the action taken. Nothing can be discussed. So complete confidentiality has to be maintained. And this again has been emphasized under the Act. One of the common things which come up in most of the minds of these aggrieved women is that I will be identified, and people in the office will get to know people at the workplace will start speaking about me very differently. So what do I do about that? Can I file an anonymous complaint? Under the Act, it is not possible. You have to come up before the committee, make a formal complaint, and they have to take action based on whatever you have said. So it is not possible to work on an anonymous complaint. However, with regard to the details, like I said, confidentiality applies. Hence, they will not be able to divulge these details to anybody whosoever. Of course, an annual report has to be filed before the relevant authorities. In the annual report, only thing that will be said is there was a complaint, whether it has been resolved, not resolved, what is the action taken. Names of the parties will still not be given out. So how to address this issue? Now, this seems to be a very big problem. So how can we actually make our workplaces safer? It seems that awareness is the key to this. Once you are able to sensitize the employees with regard to the code of conduct, if you're able to tell them what is permissible and what is not permissible, then obviously it becomes much easier for us to go ahead and curtail this particular issue. Awareness, sensitization, and having a policy of a zero tolerance towards sexual harassment has worked in many organizations across the world. So a lot of people have made this as a best practice. They have gone ahead and they have also made it as a regular thing for people to get trained with regards to how to avoid sexual harassment at workplace, what can amount to sexual harassment, how to address this, who is the internal committee member, how to approach the committee member, what is the procedure in terms of the committee addressing these issues, how action can be taken, what can be done. All that is outlined by a lot of employers effectively. One of the other things which again commonly comes up in the mind of the aggrieved woman is, yes, I have made a complaint and it will take some time for the committee to address the issue. But till then, won't I be victimized? Won't I be marginalized by the person? And if the person is the employer, that is the manager, in that case, what happens? You will have to report to that person. You've made a complaint and you have to report to that person. You think the person is going to take it lightly? No. So there is interim relief as well prescribed. So there are multiple things which are prescribed, out of which leave can be granted, or the line of reporting can be changed. Obviously, in case there is an appraisal, if it is during appraisal, the manager cannot be part of this appraisal. And if the manager is part of the committee, that is the internal committee, he has to recuse himself. He cannot be a part of that committee as well. So from protecting the interest of the aggrieved woman during the time of the inquiry as well, there are interim measures which are prescribed. And like I said, leave can be given for a maximum of about 3 months, which is over and above the leave which is available. If it is possible to transfer the person to a different department in a different office, then even that can be done. So that again, the internal committee will take a call and they can make suggestions accordingly. I hope you all have a safe work environment. Stay safe and be blessed. Thank you.